All right, are we ready for your opening, Mr. Bramble?
Yes, Your Honor.
All right, then please let's bring in the jury. All right.
Please rise to the jury.
Please be seated. Folks, sometimes 5 minutes turns into more. There are some preliminary matters, I think, before we actually get started that need to be worked out. It went a little longer than I hoped, but I hope it will not be a lot more lengthy interruptions. Now is the time when we actually begin the trial. Mr. Bramble, your opening statement.
Thank you, Your Honor. Ladies and gentlemen of the jury, as Judge Denenfeld indicated, this is my opportunity to provide you with an opening statement. What it is my opportunity to tell you what witnesses are going to come forward and what information, what evidence they're going to provide you. I ask you to listen closely because probably all the time I have to call witnesses out of order, and so if you kind of have their names and know where they fit in as far as the entire case, I think it'll help you in your deliberation process. This is an argument. I don't get a chance to argue how the facts apply to the law, but I simply can lay out what my case is, what witnesses are going to come forward, and what evidence they will provide you. I'd like to emphasize again, Judge Denenfeld advised you of the elements of the offense that I have to prove, first-degree murder. First, that is that the defendant caused the death of Michael Connor Verkerke. Secondly, that he intended to kill him. Third, that it was premeditated, thought out beforehand. And fourth, it was deliberated. It was deliberate, rather. And that is that the defendant had an opportunity to consider the pros and cons of his actions. And I think you'll find when we begin to lay all this out that not only did he have an opportunity to consider pros and cons of his actions on August 4 of 2014, but he had been considering doing this, killing someone, for over a year. He had deliberated for over a year about taking someone with him and then taking his own life. But he had thought about this and considered this for a year. And that isn't something I'm making up. Those are the defendant's own words. I emphasize that I only have to prove those elements. The defense here, and I'm going to touch upon this now and then go into it a little more towards the end of my opening statement, but really this is an affirmative defense of insanity. I don't believe the defense is contesting that, in fact, the defendant killed Michael Connor Verkerke. They're claiming he's not responsible simply because he was insane at the time of this act. Well, I asked him, and we talked about this during voir dire, that the definition of legal insanity is actually a very narrow one. What you have to find, and what the defense has to prove, and it's a little unusual in that the defense, when we get to that part of the case, carries the burden there. But they have to demonstrate that the defendant lacked the substantial capacity to understand the wrongfulness of his conduct, or he couldn't conform his conduct to the requirements of the law. And that as a result of a mental illness, again, he couldn't control his, didn't know the wrongfulness of his conduct, or couldn't conform his conduct to the requirements of the law. Before I go into the facts, I'd like to talk about Michael Connor Verkerke. I think you're going to hear him referred to as Connor throughout this, so I don't want you to, his father's name is also Michael, so they call him Connor. He was a 9-year-old boy on August 4, 2014. I'll show you a picture of him later on here, where Connor was at school the year before. He was a very likable kid. He was a very lovable kid. He was a kid who his teachers enjoyed having around. You're going to hear from his own mother that Connor made friends easily. And on August 4 of 2014, that's what he did. He made friends with the defendant. It is rare, very rare, that as a prosecutor you have an entirely and completely innocent victim. Connor Verkerke is a completely innocent victim. Prior to being stabbed by the defendant, he didn't fight with him, he didn't taunt him, he didn't share any cross words with him. What he did was try to befriend the defendant. And when he turned his back on the defendant, when he was climbing up a slide, the defendant took out a knife and stabbed him repeatedly. Now I'd like to go into the witnesses that are going to come forward and what they will provide you. You are going to hear from Jamarion Lawhorn that he and his friend James Martin and Connor were all playing outside the Verkerke home, doing as normal 9-year-olds do, just playing and running around, and the defendant walked up. And they asked the defendant his name, and he told them his name was Jamarion. And Connor then went into his house, asked his mother, "Can we run to the park and play with our new friend?" Mrs. Verkerke will tell you she didn't think anything unusual of that because Connor was always making new friends. And she allowed him to go to this park that's really within, and you'll see from some overhead maps, a close distance to their house. It's located at 444 Bellwood in the city of Kentwood, county of Kent, state of Michigan. So the boys all leave and walk down to this park. The defendant follows them. While they're playing on the playground, you're going to hear from a witness saying she observed them playing and the defendant was kind of standing off to the side. Well, at some point the defendant, who has hid this knife in the sand, and I mean, you talk about a calculating act, he's hid this knife in the sand after he has hid it, carrying it all the way from his house, and I'll get into that in a moment. He pulls the knife out, and it's a very large knife, and he shows it to these boys. They don't think much of it and continue to play. Well, it isn't until Connor comes down this rock slide, has his back, and they call it a rock slide because it's a plastic slide with all kinds of indentations and bumps on it. You'll see pictures of that. When Connor Verkerke turns his back on the defendant descends upon him with this knife. And really, you're going to find that he did it at a time when Connor Verkerke was at his most vulnerable. When he was coming down off this slide, when he had his back to the defendant, when he couldn't defend himself. And the defendant stabbed him 3 times in the back and once in the arm. You'll see photographs of these wounds. Once this stabbing occurs, Connor begins to run home with the help of his brother Cameron. And Cameron will tell you that that blood is coming out of his brother's back, and also that his brother is spitting up blood as he's trying to get him home. And he does get him home. And on the while, when he gets on his way home, I submit to you, Connor knows he's in trouble. And knows he's very seriously hurt because he tells his brother, "This isn't your fault. Don't worry about it. I love you." They reach the Verkerke home, and Connor essentially collapses on the front porch of their home. Cameron runs in and tells his mother, Connor has just been stabbed. Mrs. Verkerke and Mr. Verkerke come out and they begin to apply pressure to the wounds in Connor's back. And they'll tell you, I think, that every time they pushed hard or placed pressure on one wound, the blood would spurt out even more on another one. For all intent and purposes, Connor Verkerke was dying in their arms on their porch. "911 is called by James Martin, the other boy that was there. The ambulance arrives, but what you're going to find here is, I'd like to shift to after Connor is removed from the porch, taken to the hospital where he eventually dies. I'd like to focus now on what the defendant did. Because you're going to hear that the defendant, after stabbing Connor Verkerke, walks over to an area near the Verkerke home and says to a woman, Heidi Shepard, and another woman, Nancy Bishop, who are standing in the street just talking to one another, he walks up to them and asks, "Can I use your phone?" They indicate, and they can't figure out why he wants to use the phone, but they say, "We don't have a phone." The defendant then turns and walks up to the drive to the home of Glenn Stacy. Mr. Stacy will tell you that the defendant, who is walking fine, talking fine, asks if he can use his cell phone. The defendant gets on the cell phone and calls 911 and tells them basically, "I just stabbed somebody, come and get me, I'm tired of living." And that's going to be a theme throughout this. And you're going to hear the defendant, and it's not someone who's very apologetic for what he's done, what he has done, but you're going to hear his voice on that 911 tape. And it's an angry voice, it's an agitated voice, but surely isn't one of remorse. In some sense, you can hear it in his voice, he's almost proud of what he has done here. Once the police arrive, naturally, they go to the victim first. You're going to hear Glenn Stacy say that this upsets the defendant because he wants them to come and arrest him. And he's upset that they've gone to the victim first. Well, finally, Officer Klein, who is responding to the scene as well, shows up and begins to walk towards the defendant because the defendant matches the description provided by dispatch. And as he's walking up to the defendant says, "Come here and arrest me." And Officer Klein says, "Why?" And the defendant says, "Because I just stabbed somebody." The defendant will also say he took some pills prior to stabbing somebody, and you'll hear more about this, but they are antidepressant medication and some antibiotics. There's going to be a question as to when he actually took those, but he is going to claim that he took those at some point prior to doing this. And you're going to hear that the defendant is treated immediately by people from emergency response, AMR, and during this time period, they're talking to the defendant. He is alert. He is oriented to where time, to place. He's talking, just as you'll hear on this 911 tape where he spells out his name, talks fluently, is having no problem communicating with anyone. But what he tells these AMR people is actually quite chilling. He tells them, "I've been planning this for a year. I wanted to kill someone and then be arrested for that and have them kill me." You're also going to hear the defendant being examined by a number of other doctors who say, again, he's oriented to time, to place, to who he is, he's spelling his name, he's giving out his mother's address, his address. But you're going to hear the full story of what the defendant did on August 4, 2014. Some of this comes from the defendant himself. Because the defendant is going to tell, the defendant told people who were examining him, people who questioned him, that not only had he been planning this for a year, but on the date in question, he went into the kitchen area of his home, got out a long knife, importantly here, because he knew the wrongfulness of his conduct, because what does he do with this knife? Does he walk out openly and carry it openly? No. He conceals it and hides it. He walks all the way down to the Verkerke home, still concealing this knife. He walks with the Verkerke children to the playground. And what does he do there? He conceals the knife in the sand. And he waits until Connor has his back to him and he stabs him. The defense here, as I indicated, is insanity. That as a result of a mental illness, he lacked substantial capacity to know the wrongfulness of his conduct or couldn't conform his conduct to the requirements of the law. The defendant has been examined by a couple of psychologists, one hired by the defense, one who works for the Center for Forensic Psychiatry here in the state of Michigan. And I'm going to ask you, because you're going to hear conflicting viewpoints here. And you're going to have to look at this. You're going to be diametrically opposed and sift through this. But I'd ask you to focus on what Dr. Tremonti, who works for the Center for Forensic Psychiatry, will tell you about the defendant's mental state at the time he committed this act on August 4, 2014. And really, no one, you can't, I can't, get inside the defendant's head and determine what he's thinking at the time. What Dr. Tremonti will tell you is what governs here, what tells us what the defendant was thinking, is his conduct, his actions on that day. And his actions clearly indicated that he understood the wrongfulness of his conduct. I mean, he knew to call the police because it was wrong. And he could conform his conduct to the requirements of the law. And why do I say that? Well, Dr. Tremonti is going to tell you, again, the devil's in the details here. It's what he did. You can judge and determine his intent by what he did and how he did it. And what did he do on that day? Well, one, he'd been planning this for a year. Two, on the date in question, he gets a knife out of his kitchen, fully cognizant of the idea that he's going to go and harm someone with it. Three, he conceals this knife underneath his clothing and walks a considerable distance. And you're going to hear from the detective that he walked a considerable distance from his home to the Verkerke home and to the park, all the time concealing this knife. It's a good 5-minute walk with this knife. More importantly, what does the defendant do besides stabbing him? Before stabbing him, rather? He removes his shirt. And by his own admission, he takes his shirt off because he didn't want to get blood. He knew what he was going to do. He knew what the results of what he was going to do would be. So he takes his shirt off. Now, when you begin to add this up, ladies and gentlemen of the jury, you're going to hear one other crucial point raised by Dr. Tremonti. Because when she's interviewing the defendant, and she's interviewed him a couple times, Dr. Tremonti asked him, when you got the knife out and you hit it, what did you do then? He said, I walked outside. She said, well, who was outside? And he acknowledges, well, there were some young children out there right outside my home. They were friends of my mother. We've known them for a long time. And Dr. Tremonti asked, well, if you couldn't control yourself, why didn't you stab them? And he said, well, oh, because they were friends. Because they were friends. So he could conform his conduct. He went looking for someone who he didn't know. And that someone ultimately ended up to be Connor Verkerke. But when you begin to add this up, when you begin to see the defendant having planned this for a year, having obtained a knife with the idea of killing someone, concealing this knife in his clothing, concealing the knife in the sand, taking his shirt off so it doesn't get bloody, walking past a group of young children that he could have stabbed if he wanted to seek out an unknown person. The facts are going to indicate that the defendant clearly understood that what he was doing was wrong, and that he clearly could conform his conduct to the requirements of the law. You're also going to hear from a defense psychologist, and she will also have interviewed the defendant, and you're going to find that the defendant's story changes over time when he talks to her. And I submit to you, it gets embellished over time because the defendant recognizes what he has done here and recognizes the fix he's got himself in right now. He changes his story to such a significant extent that Dr. Tremonti will tell you he is no longer a credible source of information because he keeps changing his story and keeps embellishing. Ladies and gentlemen of the jury, I submit to you, if you look at this situation, and if the person sitting in the defendant's spot was a 30-year-old man or 35-year-old man, you would look at this and say, what a cold, calculated, brutal murder. Well, it's no different just because it was committed by a 12-year-old who's now 13 years old. This was cold, calculated, planned, premeditated. Ladies and gentlemen of the jury, when you begin to pull all this together, all the facts together that are going to come forward, the facts are going to indicate that the defendant sought out Connor Verkerke. He sought him out because he didn't know him. And on August 4 of 2014, he concealed the knife, waited till Connor Verkerke's back was to him, and stabbed him to death. The facts are going to indicate the defendant, based on all the facts and circumstances here, is guilty of first-degree premeditated murder. At the conclusion of the proofs, on behalf of Connor Verkerke and the people of the state of Michigan, I'm going to ask that your verdict reflect that.
Thank you, Mr. Bramble. Mr. Buckley, you choose to give an opening at this time.
Yes, sir.
All right.
I often think that the perfect juror would be an author or a movie director. And why? Because you're going to be hearing things out of context, it appears, out of order, simultaneous lives happening, and you're going to have to put it all together in your mind before you can put out the book or put out the movie. You're going to have to keep that order in your mind as you go through this. You're going to be finding out things that you wish you would have known before you heard someone else testify. That's one of the reasons why the law allows you to take notes. And if you want to do that, that's one of the main reasons for it, so that you can put it all together in proper context at the end. There are simultaneous lives here. There's the life of Michael or Connor Verkerke. Mr. Rail's right. Totally innocent victim. Didn't deserve this. Tragic. And then there's the life of Jamarion Lawhorn. And you're going to learn about that as well. And you'll draw your own conclusions about that as well. But some of the things you're definitely going to hear about is that he was abused and neglected almost his entire life. You're going to hear things that happened in 2005, things that happened to him in 2013. Oh yeah, about a year prior to this. You're going to hear that he was beaten often with an extension cord in his back and his legs, whipped by his stepfather. You're going to hear that he was hit by his mother with a belt. You're going to hear that he tells people, I'm bad. I must be bad. I'm a bad person. You're going to hear that this abuse gets disclosed to people at school. This abuse gets disclosed ultimately to the government through CPS, people that are supposed to be protecting children. And the parents are investigated. And actually, even the parents admit some of this took place, especially in 2013. And you'll see photos of the scars a year later of what took place to him. And you'll hear testimony at the school recommended he should get some treatment. He should get some help, some mental health help. No child can go through this without getting some help from a professional. And then, in 2013, another investigation took place because of these scars, because of this obvious abuse that he disclosed. And unfortunately, nothing was done except they decided, well, let's have him move in with his father in New York. And he was with his father for a year. But then he came back and lived with his mother and his stepfather again. And he thought, and at that point, you'll hear that things seem to be going well. Maybe now it was over. But then, for a week prior to this incident, you'll hear testimony that it'll be conflicting. Some will say abuse started again. Some will say he was threatened every day to restart all of this abuse again. And all the same things come back to him. And did he do actions that would reflect what he was thinking or what was happening to him? Yes, he'd get in trouble. He'd get in trouble at school. He'd do things that you'd shake your head and go, well, why is this happening? He'd set fire to a bed at his home. And you'll hear testimony of that. And what was done? Did he go to for any mental health assistance, any mental health treatment? No. And you'll hear testimony that when the parents were confronted with this, well, you should get him some help. And they'll say, yeah, we'll do that. And you'll hear testimony that they didn't. And then you'll hear that he came back again. And he's back. And he encounters what's going to be a repeat of what he was living through before when no one did anything about it. And so he said, I just can't deal with this anymore. So he takes pills, his mother's pills, psychotropic medication, sitting in the bathroom. And you'll hear testimony that was in his system after this incident. They found the existence of these drugs in his system. And what does he tell these people who investigate? There's a lot of things that Mr. Bramble's right. A lot of things are inconsistent. But one thing that is consistent, I want to kill myself. He tells everybody that. I tried to kill myself. I took these pills. I don't know what I'm going to do. I'm going to stab someone, so they'll put me on the electric chair. Or they'll inject me with a substance that'll kill me. Or they'll put me in jail for the rest of my life. That is where this young man was at that time in his life. That's the kind of thing he was living under. You're going to hear testimony that just prior, within an hour, maybe less, we don't know exactly, but prior to this incident happening to him, you'll hear testimony that he was on punishment in the home. He was already not doing his chores, and he was on punishment. And what happens then? He happens to be on the computer. He's been told not to be on the computer, but he gets on the computer. And stepdad calls home. Talks to his little sister. He says, how's Jamarion? Well, Jamarion's on the computer. All right. Stepdad says, let me talk to him. And you'll hear testimony of what they talk about. Okay? It'll be up to you to decide what the actual story is. But after that conversation, you'll have to decide what his state of mind was. You'll have to decide what he did and why. Because ultimately, that'll help you determine whether or not he fits the definition of being legally insane. Of actually committing this act, which is not denied. Indeed, he said he did it right afterwards to everyone. There's no inconsistency there. And Mr. Bramble would have you think that he was deliberate and had appreciated the full wrongfulness of what he was doing. But I'll submit to you that after you hear the testimony, there's another explanation. It's equally plausible, if not more so. And that is, he didn't really appreciate the wrongfulness of his conduct. That he was, at that point, so overwhelmed by what he'd been experiencing his whole life and what he was about to experience when his stepfather came home. And understanding that every time he went to an adult, they failed him. That he had no choice. This was his only way out. He even tried to kill himself. And that failed. And ladies and gentlemen, when you cut through all of the evidence, that's what you're going to find. And you're going to hear a lot of testimony both ways, who said what and when, and some of it will be consistent and some of it will be inconsistent, and you'll have to use your common sense to determine what really happened. And Mr. Graham was right. There'll be testimony from experts on both sides. Dr. Rao will testify. And although Mr. Bramble says Dr. Rao was hired by the defense, actually he worked for the same center, Chief worked for the same Center of Forensic Medicine as Dr. Tremonti, actually examined quite a few more people for the Forensic Center than Dr. Tremonti has done. And certainly applies the same standards. They happen to disagree. It'll be up for you to determine who you believe is more accurate. Or you may not believe either one. But the one thing you will hear from everyone is that at the time before, during, and after this incident, Jamarion Lawhorn was mentally ill. That won't be a problem for you to find because no one's going to say he wasn't. No expert is going to say he was not mentally ill as a result at the time of this incident. So that prong of your test is already decided, will be. And then you'll just have to determine what's left. And you'll go back and obviously deliberate. And no one will dispute what a horrible tragedy this is for the Verkerke family. And no one will dispute that he didn't deserve it. There's no question about that. But you're going to have to determine if he was the only victim.
Thank you. Mr. Buck? Let's take 10 minutes. We'll come back and we'll hear the first witness. And then my intent is that we'll go until a lunch break. Thank you very much. We'll excuse the jury. Please rise. Please be seated. Court clock is 10:25. Let's restart.